All right, guys, what you've all been waiting for, my summary, my review of the redistricting and gerrymandering Supreme Court cases. And no, I couldn't figure out how to get my kids involved in this one, so it's just me. But I know we've talked about this, but I think I need to review it just a little bit. So let's start with Baker v. Carr. Baker v. Carr was a case involving redistricting in Tennessee. And you had Christopher Baker, who lived in an area right by Memphis, and that population had grown dramatically over the last few decades. And in his area, he had maybe 10 times more people than someone living in the sticks in Tennessee, where they don't have a lot of people around them, but they still have as many. They have one representative compared to Baker's one representative. So Baker is represented far less than someone living out in the sticks where there's not a lot of other people. Tennessee had not done any redistricting for about 60 years. So Baker takes this to court, and he's arguing that we need to do some redistricting here. My equal protection rights are violated. So he's using the equal protection clause of the 14th Amendment. So here's what the court says. The court says essentially, basically what this case does is it says that districts have to be House of Representatives districts, congressional districts have to be roughly the same size in terms of population. And the principle, this is the term that comes out of it, one person, one vote. So we want people to be represented equally. And that's really the big legacy. And the big kind of takeaway in terms of the Constitution is Baker v. Carr uses the 14th Amendment Equal Protection Clause. So one person, one vote. This is why we have equal size districts, and every 10 years we have to redistrict. And as you know, we had the guy from the census in this year. We are redistricting here in a couple of years. The census is taking place now. By the way, have your parents fill out their census form. So Baker v. Carr, one person, one vote. The next one is Shaw v. Reno, and this is North Carolina. And basically this involves a situation where North Carolina is going to create a district that is a majority-minority district. So what that means is that the majority of people in that congressional district are a minority, in this case, African Americans. So the constitutional question in Shaw v. Reno is, does this racial gerrymandering violate the Equal Protection Clause of the 14th Amendment? And as you can see here, here's the picture. It's this pink district right here that goes all over the place, obvious gerrymandering. And North Carolina admits it. They're like, yeah, we did this to try to make sure that there's an African American representative. And this goes back to the Voting Rights Act of 1965. And essentially, they're trying to make sure that there's an African American representative. The problem with this can be that if you group all African Americans in the same district, they're going to lose their representation in the other districts, or their ability to kind of get heard in these other districts. So there's a lot of things going on here, but here's what the court says. The court, in a split decision, 5-4, said that yes, District 12 was clear. There was gerrymandering there, which North Carolina admitted. But the court says, yes, it is a violation of the Equal Protection Clause. And the court also, and this is important, the court says race can be a factor when you're drawing districts, when states are drawing districts, because it's the responsibility of states to do the redistricting. Race can be a factor. It just can't be the only and obvious factor for the entire district being drawn. So in this case, the court rules that it is a violation of the 14th Amendment Equal Protection Clause. You can't have race be the only factor. And this case also does kind of set the precedent that states can draw their own districts, and there can be some forms of gerrymandering, political gerrymandering. Race can be a factor, just not the only factor. And I think a good way to compare this would be to think about affirmative action, because there's been similar rulings with the court on affirmative action. Example would be Bakke versus Regents of California, where the court said, look, when it comes to affirmative action, schools can consider race as a factor. They just can't use quotas and make it the only factor. So similarly here, Shaw v. Reno, court says, yes, race could be a factor, just not the only factor. So complete racial gerrymandering, not allowed. So Shaw v. Reno and Baker v. Carr both use 14th Amendment Equal Protection Clause. Those are your redistricting, gerrymandering cases. Thanks, everybody. You got a quiz coming up Thursday. Open book, open note. Make sure you review the cases. Also, might be trying to do a little Zoom video conference, Kahoot type of thing here, potentially this week, but we'll see how that goes. I'll make an announcement about it on Classroom. So take care, everybody. Talk to you later.